Kicking off now. There we go. Okay. Yeah, so I'll kick off now, and if anybody else is going to join, they can join as and when they arrive. Good afternoon, everyone, and thanks very much for joining us today on this webinar. I'm going to share my screen. So my name is Gary Shaw. I'm the Key Account Director for Tower Street Finance. I'm going to be chairing this meeting today. Can you see that, Andrew?
I can.
Perfect. Okay, brilliant. I just wanted to make sure. So I'm the chair for today, and I'm also going to be doing a little bit of a presentation later on. So it's just to say thanks on behalf of the Surrey Law Society for joining us today, as well as ourselves as one of the sponsors. The session is one of a variety of webinars available free of charge to Surrey Law Society members over the course of the year. And on your screen, there's a few other events that are coming up. So managing complex family dynamics in the probate process, which is on the 24th of May, maximizing income and increasing your profit margins, practical points for fee earners on the 14th of June, and then the Past President's Championship Cup on the 15th of June, which is always a great event as well. So yeah, this one is the Contentious Probate Issues and Funding. Just a little bit about the session. It's going to examine two key subjects addressed in case law over the last 12 months, namely undue influence and fraudulent calumny with challenge, put up or shut up orders. The webinar, which will be co-presented by Andrew Morgan, who is a senior associate at Russell-Cooke, specialising in relation to succession, probate and trust disputes. We'll discuss practical tips as practitioners. It'll also provide some insight into the development of the UK probate funding market, more specifically probate funding from a litigation perspective, and how potentially Tower Street Finance can assist in some of these matters. Just some general housekeeping rules. So there's a Q&A function within Zoom. If you've got a question which you would like any of the speakers to answer during the webinar, feel free to put it in there. I'll try to pick it up at the end when Andrew's speaking, and then I'll ask those questions to Andrew from there. If you'd like to speak to one of us at the end of the session, you can do this by raising your hand function, and then we can take any additional questions thereafter. As you probably heard, the webinar is recorded and it will be made available to all the members after the event. Just a little bit about us. So Andrew's going to kick us off. Andrew's a senior associate in the Trust and Estate Disputes team, advising on a range of succession, probate and trust disputes. His work spans claims pursuant to the Inheritance Act 1975 Act claim, domicile disputes, will challenges, will construction and rectification claims, property trust disputes, and trust, estate and administration issues. I hope I got all that right. Andrew qualified as a solicitor with Russell-Cooke in September 2016. And then I'll follow Andrew with a little bit of a presentation. So as I mentioned, I'm the Key Account Director for Tower Street Finance. I cover the south of England, and I look after all the key account partnerships between professional administrators and Tower Street Finance. And without any further ado, I'm going to hand over to Andrew, who's got some slides that he's going to share. Andrew, over to you.
Okay. Thank you very much. Going to do my best to share my slides. Hopefully you can see those now. Gary, can you?
Yep.
Good stuff.
Got it.
So thanks very much, Gary, for the introduction, and welcome everyone. So when it comes to issues and funding in contentious probate, my focus is very much on the issues side of things. Now, over the last 12 months, perhaps the best known reported case anyway, is probably the Supreme Court's decision in Guest and Guest. However, I have deliberately focused on three relatively overlooked decisions, as I think they present some useful takeaway points, and also because I think they concern growth areas in contentious probate. So in terms of the three decisions, the first concerns a will challenge based on undue influence. So that's, of course, where the will is the product of coercion. The claim was successful, and in my view, that the bar for success was relatively low. And the focus here is really, is this a one-off, or is it part of a bigger pattern? The second decision concerns a will challenge based on fraudulent calumny. which is where person A poisons the testator's mind against person B to cause a change of will. Now, the claim there was unsuccessful, but the takeaway point that I'm focusing on is whether independent legal advice can break the chain of causation. In other words, whether good independent legal advice from a will writer can prevent successful fraudulent calumny claims. Third concerns a very politely named put up or shut up application. As the name suggests, this is effectively an order directing that if a claim is not issued, then distributions can be made on the basis the claim cannot be brought. The context here is really stalled administration, but we'll get into that. And our particular focus is on what the claimant needs to do in terms of disclosure to bring these applications. In terms of growth, I think these areas are becoming more and more prevalent. And I know that from personal anecdotal experience. But also I thought I'd just do some research on Westlaw. And the statistics there kind of speak for themselves, particularly big increase in fraudulent calumny cases over the last 18, 15 years or so. There are relatively few put up or shut up cases. There's a case in Parsons last year, which I'm going to come on to, but I do expect those figures to increase in the coming years. So let's get into it. And the first case is about undue influence. So just to do a quick recap on the relevant law, Rhea Edwards, a quote on the right, effectively summarizes it actually relatively neatly. The question in the end is whether in making his dispositions, the testator has acted as a free agent. So unlike challenges to lifetime transactions, there is no presumption here of undue influence. It's a question of fact to be proved on the balance of probabilities by the accuser. You need coercion, which is effectively overpowering pressure. But persuasion is absolutely fine. And that's something I think to bear in mind when we come on to the case I'm going to talk about in a moment. And the physical and mental strength of the testator are relevant when assessing undue influence. So the case of Harrison and Barrett, number one, this was decided a few months ago in February, mid-February this year. It concerned the late Julie Harrison, who died in April 2020, aged 88. She was a widow. For whatever reason, the tabloids have focused almost exclusively on the fact that her husband invented elements of the Hawker Harrier jump jet. I hope I got that right. And in fact, paid very little attention actually to Julie herself, which is unfortunate. But the takeaway point for us are Julie passed away leaving a daughter, Candice, and also a nephew, Jonathan. She made at least 2 wills. 2012 will left the residue to Candice. 2017 will left 400 grand to nephew, Jonathan, and the residue also to him too. Candice brought a claim in April 2021. It was a will challenge, and that's what we're focusing on. She also sought some relief about setting aside certain deeds, which I'm not going to go into actually in today's talk. Bit more background. There were substantial payments to nephew over 2011, 2012, 2016. The enduring power of attorney was registered with Candice as the attorney in February 2014. And that followed up by the nephew introducing Julie to new solicitors. So there was a change of solicitors between the 2012 will and the 2017 will. In June 2017, there's a diagnosis of late onset dementia. And then a few months later, before Julie executes her final will, a consultant psychiatrist in fact concludes that she held testamentary capacity. Now that report is going to come up under some criticism, but before the will was executed, there was a favourable, an expert's report concluding that she did have testamentary custody. A year after the will is executed, a video camera is installed. Now, the deceased consented to this. It looks like the deceased was could recollect that people were visiting her, but she couldn't recollect who it was. So the carer got wind of this, and as a protective measure, a video camera and a microphone were installed. Now, those recordings become very, very relevant for the undue influence challenge. And the recordings show the nephew using Julie's fear about being put into a care home to try and turn Julie's relationship with her daughter in a negative light. The judgment, as I said, came out a few months ago now. The will was set aside on the basis of both a lack of testamentary capacity and also a finding of undue influence. Just to touch briefly on the testamentary capacity, as I said, the earlier experts report came under some criticism. Amongst other things, it didn't seem to be aware of the dementia diagnosis. And there's also some criticism that some purported facts were taken as read without challenge. Also, there was expert evidence from Dr. Warner, some lay witnesses, and the video evidence became relevant to this assessment testamentary capacity. But our focus is really on the undue influence side of things. But I just want to quickly recap what I said earlier. What we're looking for is coercion that overpowers. Basically, the testator is no longer a free agent because they are subject to overbearing coercion. And that is distinct from persuasion, which is fine, it is legitimate. Master McQuail decided the judgment this year, and I'm not going to read out that very long quote, but I'm just going to focus on a few key elements. So she finds that Jonathan embarks on a campaign of influence where he uses and amplifies Julie's concerns about the care home to turn her against her daughter. And this campaign of influence is used by the nephew to persuade Julie to leave the nephew money in the will. The nephew introduces Julie to the new solicitors. The nephew was present and involved in all of those meetings about the will, and the nephew visited Julie on a regular basis. I think on the face of it, as someone who's been involved in undue influence disputes for a few years now, there are a few surprises there, especially in terms of the language, which I'm going to come on to, especially in terms of the takeaways. So for litigators, I think that decision sets a relatively low hurdle for success. As mentioned earlier, persuasion is meant to be legitimate. So it's surprising to see reference to the nephew persuasion being part of a campaign of undue influence. The word persuasion is used by Master McQuail. And I think this is reinforced really in a particular point to bear in mind, concerns causation. Now, Rhea Edwards in the mid-noughties in 2007 made clear that if you want to be successful in bringing a will challenge, you must show that the facts are inconsistent with any other hypothesis. Basically, you need to show that only the undue influence can explain the will. If you can find another explanation, then you can't win an undue influence claim. And practitioners thought that set quite a high hurdle in practice for claimants to overcome. Well, I've looked through the judgment and I cannot see any detailed grappling with this issue. It's almost just, it's mentioned in terms of something to be satisfied in the usual summary of the relevant law. But when it comes to the application, it's given barely any detailed assessment. I should point out, perhaps as a word of caution, that the nephew was underrepresented at trial. And perhaps it may have made a difference if some representation was in place. For example, at the last moment, the nephew tried to actually extricate himself from the proceedings on the day of the hearing, if I remember, which Master McQuail dismissed. Ultimately, what we're going to need is basically another case to work out, is this low hurdle here to stay, or is it just a one-off? It is just a High Court decision for the moment, so we basically need another case here. Next up for litigators is there's a very strong overlap in the judgment with fraudulent calumny. So looking at the judgment again, we have words like turning the deceased against her daughter, and things like this. Very much the language of poisoning mind, the language of fraudulent calumny. And moving forward, I do expect these two, i.e. undue influence and fraudulent calumny, to be pleaded together and in the alternative. Third and final for litigators, you cannot begin a case too soon, I guess, is perhaps the easy takeaway here. It's the lifetime evidence gathering that was absolutely key in this case. The claimant made transcripts of the recordings, and they turned out to be referenced in the judgment. One notable reference is, and I'm quoting, this is from the nephew now, quote, "Oh, that is 3 years of work. Big sigh, dear God." This is in the context of him beginning to think that things are unraveling. And obviously, without knowing that there's a video camera and a microphone set up in the deceased's home, this is something that he says. And the court uses it as a hook to infer that the campaign of influence is in fact a campaign of undue influence. So I think it's important to bear in mind some of the timescales here. The recording begins a year after the will is made. So on the face of it, I think perhaps any evidence is just too late to shed much light on things that happened a year earlier. But the nephew stumbles and says these words. And I think that video evidence ties everything together. It shows that there is a systematic campaign of undue influence going on here. For private client lawyers, there are fairly standard warnings about being careful about the involvement of third parties in will instruction, which I'm not going to spend too long on. But it's the next bullet point, which Master McQuail touches upon her judgment with the quote on the right. The solicitor took no proper steps to evaluate the influence that the nephew had over the deceased. I think that imposes quite an onerous obligation in practice. On a micro level, that effectively means things like maintaining good records about new inquiries. If someone's picking up the phone to ask about a will for their grandmother or relative, details like that are going to have to be recorded well. Fact-checking what testators are saying probably involves meeting them on neutral territory, your office, and that's going to be problematic for some clients. And it may involve multiple meetings to sound check and fact check what you're being told. Ultimately, that's going to be a timely, costly process. It's difficult to be too prescriptive, but the big picture is be careful with assumptions and fact check. That's it for undue influence. Moving on to the second decision and fraudulent calumny. Ree Edwards, again, actually provides a very useful recap of what we're looking for. So it's where person A poisons the testator's mind against person B, and that causes a change of will. There's a recap also on the left-hand side of the slide. I'm just going to bear in mind one point, is the final one, which is a reminder that if someone believes that they're telling the truth, even if it's objectively untrue, then fraudulent calumny fails. It's not something that I'm going to talk about in much more detail moving forward, but just a useful reminder. But the case of Sharp and Dyson was decided again in the High Court, and this time it was last year. Brian passes away in May 2020. He makes at least 2 wills. The 2003 will passes his residue to his partner, Mrs. Dyson. But if she predeceases him, and she did, then the residue would go to her sons, Mr. Dyson and Mr. Ellis. Brian then makes a later will, and the residue is to pass to Mrs. Sharp. Mrs. Sharp is the sister of Mrs. Dyson, is the sister of his late partner, Brian's late partner. In middle of 2020 to late 20, we have the usual pre-action will challenge of caveat, warning, and appearance. Ultimately, the sister, the Mrs. Sharp, she brings a claim in the middle of 21 to propound the later will. And then it's a counterclaim by Mr. Dyson and Mr. Ellis on the sole basis of fraudulent calumny. So that's key. Only fraudulent calumny is pleaded. Though the court does say, look, I also have to look at other things. I have to look at things like capacity and undue influence in order to look at fraudulent calumny too. The counterclaim was unsuccessful, so no fraudulent calumny here. And the 2019, the last will, was propounded. The allegations were not made out. So these were things like, as set out on the slide, that the sister was telling Brian that the defendants wanted to take Brian's money. It looks like there was a falling out in terms of the administration of Mrs. Dyson's, so Brian's partner's estate. And in fact, that particular allegation, the court found that actually there was money that was unaccounted for, and the allegation wasn't made out. But it's not so much the substantive decision that I want to talk about, or the allegations that I want to talk about, but it's a point of causation. Again, apologize for the very long quote, but I'm not going to read it. It's there if anyone wants to have a look at the slides afterwards. Key bit is in bold, really, where the court is saying, I didn't find fraudulent calumny, but if I did, it would have been negated by the advice of Mrs. Ridgway Coates, who was the will writer, the private client lawyer. It's not automatic. Independent legal advice does not mean you cannot bring a successful fraudulent calumny claim, but it was relevant. And in this case, the court said, again, even if there was this fraudulent calumny, her advice would have negated it. Effectively, the independent advice had a curative effect on what would otherwise have been a will set aside for fraudulent calumny. This builds on a previous case, the case of Todd and Parsons, and I give the citation and relevant paragraph there in the slide. I mentioned that because I think it's a useful point in relation to undue influence. So in Sharp and Dyson, the High Court focus was on fraudulent calumny, saying, well, the advice of Mrs. Ridgway Coates would have cured this fraudulent calumny. But actually, Todd and Parsons provides some authority that the same could take effect in relation to an undue influence claim. In other words, good independent legal advice from a private client lawyer can go some way to defending a undue influence will challenge. One thing to perhaps bear in mind in Sharp and Dyson was that the will writer came off extremely well. Her notes were clear and she gave very good evidence. As said on the first line on the top, her evidence, was accepted in its totality. Moving on to the final decision, and that's in relation to put up or shut up orders. Now, as mentioned earlier, these orders are effectively seeking a direction that if someone doesn't bring a claim, distributions can be made on the basis that the claim cannot be brought. To put this in some context, the short point is think stove administration. The longer point is probably best illustrated with an example. So you may be an executor, or you may be acting for one. You may have got the grants. You may have even made some interim distributions. And you're at the point of preparing final estate accounts when someone pops up and says, wait a minute, I think this will's not valid for X, Y, and Z reasons. What do you do? Well, there is no statutory limit on bringing a will challenge, though there is the doctrine of latches to be concerned about. So in theory, someone could pop up at any time. Now, Section 27 of the Administration of Estates Act 25 protects a personal representative if they make a payment in good faith. Now, query whether a personal representative acts in good faith if they distribute knowing that there's a potential claim out there. And that's really what we're concerned about. It's that knowledge. So what do you do? Well, in the early noughties, the case of Sherman provided some authority for the put up or shut up. And as it says there, in basic terms, you're seeking an order that someone must bring their claim by a certain time limit. If they do, you litigate it. And if they don't, then distributions can be made, and the personal representatives enjoy the peace of mind that comes from the fact that they can make those distributions without fear of a claim against them. Parsons and Reed is a recent another High Court decision case in 2022, and this time it's about put up or shut up orders. So William passes away in 2018, and he has an estate of about $3.5 million. His last will leaves his residue on full discretionary trusts for his two kids, Stephen and Judith, and his grandkids. He leaves a letter of wishes and says that payment should be made to Stephen to meet some debt obligations. And then once that's paid, 60% of the remainder goes to Stephen, 40% to Judith. The executors and trustees are the deceased solicitor and separately the deceased land agent. There is some correspondence about the funds due to Stephen, and ultimately the executors and trustees complete a deed of appointment in January 2020. That leaves about 600 grand to Stephen, and then, and as per the letter of wishes, 60% of the remainder to Stephen, 40% to Judith. April, May 2020 and September 20, we have interim distributions. Then Judith pops up and starts complaining about the £600,000 sum. And she asked for an undertaking that the executors and trustees won't distribute. This is followed up with a letter of claim. But the key is that between then and the claim, there's this limbo where Judith's not pursuing the claim. She's not issued it, but she hasn't withdrawn it either. So the executors and trustees in August 21, they make an application for a put up or shut up order. And our focus is in fact on a directions hearing. Specifically, what do you need to do? What disclosure do you need to do if you're bringing one of these claims? Judith said, wait a minute, this sounds and smells like a blessing application. It sounds like a category 2 public trustee Cooper category 2 application. Because in effect, what the claimants are asking for is an order that gives up my right to challenge their decision. So it's a blessing. And because it's a blessing, I need full and frank disclosure, thank you very much. And that in practical terms means the trustees giving all relevant facts and documents about how they reached the decision. The claimant said, wait a minute, this isn't a blessing. I'm not asking for approval, so I definitely don't need to give you full and frank disclosure. It's a very simple point. Judith has enough time to bring her claim. I just need an order that says either she brings one or she doesn't, and if she doesn't, I can distribute. Master Clerk decided again, directions hearing, saying actually full disclosure needs to be provided. There's a supporting reference in Lewin as well on the slide. Ultimately, Master Clerk's focus was that at a final hearing, someone's going to have to decide whether Judith's potential claim was, quote, insubstantial, remote, or speculative. And that requires consideration of all of the relevant material about the merits of her claim. And ultimately, Master Clerk said, look, Judith should not be worse off under a put up or shut up application than if a blessing application had been made. Looking at the draconian effect of what was going on, i.e., in practical terms, Judith's right to challenge the decision would be extinguished. So in terms of takeaways, I think the focus is very much on executors and trustees. And it's effectively a recite of just good basic practice. Gather relevant information, take into account relevant factors when making decisions, record the decision. That's perhaps the key in this case. But if you're seeking effectively either a blessing or a put up or shut up protection from the court, you've got to be prepared to give full and frank disclosure. I actually think it's probably worth working in reverse. If you proceed on the basis that everything you do may be subject to full and frank disclosure, have that as a starting point so that everything is in place, that if you need to go to the court down the line, all your ducks are in a row and you can hand it over and be confident of the merit of what you're seeking from the court. That's it from me. I'm happy to deal with questions as they come. But otherwise, over to you, Gary.
Thanks. Thanks for. Oh, sorry.
Should I stop sharing my screen?
Yeah, you can do. Thanks, Andrew. Yeah, thanks very much for that, Andrew. It was a really interesting presentation. I mean, obviously, from my perspective, not having a legal background, some of these matters become really interesting to me. And I think one of the points I made some notes was the put up or shut up element to it, in terms of you often have people who may have a strong claim. This is what we see. They may have a strong claim to an estate, but they don't have the funds to ultimately log that that claim itself. So yeah, that's obviously just an observation from my side as opposed to a question. But yeah, I don't believe there's any questions at the moment. I'm sure there might be some at the end, but thanks very much, Andrew. Thanks for that. I'm gonna just reshare my screen, so just to jump into my piece just with regards to funding, and I think that point about not having funds to make a claim actually leads quite well into my piece. Andrew, can you just tell me if you can see that? You got that?
Yes, I've got your slide.
Perfect. Okay, perfect. So as I said, we are we're a patron partner of the Surrey Law Society, Tower Street Finance. We are the experts in probate lending currently. I was just working through the list of the attendees on the webinar today, and I have been fortunate enough to meet some of you in person. So a lot of you will know what we do and how we do it. This is a very brief introduction of the funding that we offer into probate and contentious probate, into the contentious probate world. It gives a bit of a flavour as to who we are, where we came from, and what we do. So just what we'll cover today. So I'm just going to cover a little bit about us. The probate process, obviously very conscious that you're all very aware of the probate process itself. Just some statistics, what our products can do, as well as the financial structure, and just a summary. So very brief. And then there's just a quote just in terms of what probate lending actually is, which, as I say, you're all aware of that. Okay, so just a little bit about us. We were founded in the middle of 2018, or light bulb moment in 2018, founded in 2019, following very extensive solicitor and customer research. We received FCA approval as a lender in mid-2020. That period from 2019 to 2020 was thanks to COVID, and that there was nobody actually working in the FCA at that time. We did our first inheritance advance in September 2020. We won British Wills and Probate Innovation Award in October that year, and we've since launched 3 more products. To date, we've advanced just over 60 million, and we recently secured £100 million worth of funding through our private equity partner, who are Pollen Street Capital. Just some of our awards, some ratings that we have, and then we also partner with the NACFB, FIBA, as well as Cruise Bereavement. Okay, so this, I'm not going to spend too much time on this, and I think the point with this is that this process is drawing out further and further more often than not. So we know that this process is lengthy. We know that it's getting lengthier as time goes on because of departments that have system issues, staff issues, wherever else the issues may be. So we know that there will be a need for estates for funding more often than not, just because of the length of time that it takes from death to get to distribution. So we did some research. We went out and we surveyed some customers to find out what was important to them if they were dealing with a probate matter, and these were the responses that we got. So we asked the question to 5,000 people at the time. This was just to determine whether there was a need for us, and the results came back pretty shocking, to be fair. So 50% of people involved in probate expect their law firm to help them through the process, including cash challenges. Now, that was specific to IHT, so a lot of lay executors would expect the law firm to pay the tax. 50% think that the executor is not responsible for settling the IHT. 18% would want to keep a house if that was part of the estate. 70% of people don't even know what the probate process is. 50% don't know how long it takes. 72% would expect some sort of inheritance. 40% would use their inheritance to pay off debts. That numbers surely must have increased now with the cost of living crisis. And then this one here, which I've just highlighted, 40% of people would dispute a will if they needed to and had the funds. 50% expect their solicitor to provide options to solve all of these problems. So those were just some very high level stats which we got as to the way that individual people look at this whole process and the professionals who work in the process themselves, and what they ultimately expect you to do for them without knowing. If 70% of them don't know what probate is and 50% of them expect you to ultimately fund their cash challenges for them, I think, yeah, there were some pretty shocking stats in there. Just a little bit about the probate lending market in the UK. So we built this model based on, so we looked across the pond. Probate lending is huge in America, but it's very different in the sense that it's not regulated. And a lot of probate lenders over there will ultimately buy an inheritance from an individual for a portion of what it's worth. The general figure is about 25%. So they will buy a full inheritance, pay 25% for it, and effectively cash in on that full inheritance on completion. As again, there's no regulation on it, which means that they can get away with that. So we had a look at the UK probate lending market. So population of 65 million people with annual deaths of around about 600,000. Over £80 billion is inherited each year, an average of £166,000 per beneficiary. Over 200,000 estates worth over £100,000 pass through probate each year. 30,000 estates face an inheritance tax bill. The average bill is circa 200,000. I think that's a little bit higher in the southeast. Funeral and property expenses cost on average £15,000. So those are just some of the costs that are going to be experienced. It takes on average 12 months to pass through the administration process. We know that some take a lot longer than that as well, specifically if they do become contentious. 1 in 3 people would like to receive their inheritance quicker than the current process allows. Okay, so what did we do? So we went out and we developed these 4 products. Effectively, the 2 purple ones are executor products and the 2 blue ones are beneficiary products. The executor products do what they say they would do, so we can step in and pay IHT on asset-rich and cash-poor estates. We can also fund any other testamentary expenses in the estate itself. So that mostly at the moment, that is generally the administration costs. solicitors' fees, funeral costs, anything that's considered a testamentary expense, we can provide a facility to the estate to fund. And then, probably more relevant to this webinar, the two blue products. The first one, inheritance dispute funding. Now that is effectively a unique loan for beneficiaries to cover the legal costs to dispute an inheritance. So we can fund the litigation fees of that. I'll get into the details of it in a second, but effectively that facility is made available to the solicitor, not to the would-be beneficiary. So the solicitor controls the drawdown on that facility itself. And then the inheritance advance. So the inheritance advance allows beneficiaries to access a portion of their inheritance sooner. So that's the classic grief to greed. I want my money now, can't wait another year. Didn't realize it was going to take this long. We can give an advance on the back of the beneficiary on what that beneficiary is due. Okay, so just the structure of the executor lending. This is really simple, so I'll skim through this. So we can pay all or part of the testamentary costs. We pay it directly to the solicitor or otherwise to HMRC in the case of IHT. There's no repayments and no personal liability, and the loan is repaid at distribution as a testamentary expense. We insist that the case is professionally administered in all circumstances. That gives us our cash trap, because ultimately we know that you will be in control of the funds themselves, or the solicitor will be in control of the funds. We are then repaid as a estate creditor at the end when the estate has the funds to do so. It doesn't matter if the executor or personal representative are replaced, it still qualifies as a testamentary expense and it ranks senior to any other distribution. Payment is made to HMRC directly on IHT loan. A little bit of a structure about the inheritance advance. This one often, it sort of overlaps into the dispute funding world as well, because often if you're dealing with an estate where there's a beneficiary and the beneficiary has been left the full amount, for example, and somebody comes along and they log a claim because they think that they should be entitled to a portion, we can lend to the beneficiary that you're dealing with, who is already a beneficiary according to the will. Perhaps there's another will, but we can take a view on that as we get into the nuts and bolts of it. But ultimately, we can give them an advance on their funds in order to pay for the litigation. Just in terms of the claim that's come in. So simply put, if they want funds for anything, including litigation, if they are a beneficiary of the estate, we can look at it. We have a 14-day cooling off period on advances of less than £60,000. Okay, then this one is our most complicated product, as I'm sure you can understand. So on this particular product itself, we can look at funding disputes. However, we need to understand the case. We don't take a legal view because we're not lawyers. We take a commercial view. So we will always look for a source of repayment. So in other words, if we lent this individual the money in order to take this to trial or whatever it may be, how are we going to be repaid? So where are the assets in the estate? Because we lend to the estate. Who's administering it? And what is the worst case scenario that this individual is facing? Is the worst case scenario that if they lose, they get nothing? Is the worst case scenario that if they lose, they get 50% as opposed to 100%? If that's the case, we underwrite on the worst case scenario itself. The only way we can establish that is by having a conversation with you, because every single one of them is different. And sometimes information comes to light later on. So you would have a bundle of information now, but in 3 months' time, that information may change. I think going back to Andrew's comment about the recording that was happening in that particular case, that's clearly something. If there was a claim before that, then that would be something that would change our decision ultimately. We will fund the case from start to finish. So if we approve funding on a case, we're not going to pull the plug halfway down where we say, okay, it's getting too expensive now, we can't fund this anymore. As long as there's enough in the estate, we will fund it from start to finish, and we'll provide a facility in order to do that, which the solicitor draws down on, and the estate will pay interest on the drawn down amounts as we go along. We're fully aware that there's certain stages during the litigation process, and they start off potentially being fairly reasonably priced, and then obviously when it gets to court, those prices then escalate from there. So we're quite au fait with the stages of litigation itself. All of the products share a common DNA, so we don't do any credit checks, no charge over property, there's no estate shortfall risk, no monthly repayments, no personal liability, no requirement for a will, no early repayment penalties, no liability on the solicitor or administrator. We only need to see a source to repayment. We don't have a typical customer. As you know, every single probate matter, or contentious probate matter in particular, is very, very different to us. So we try to understand as much as we can where the need is and where the source of repayment is. Those are the three key points that we look at. Just in terms of our financial structure, so we charge a monthly interest rate. We are a bridging loan provider, and we are unsecured in the sense that we don't take a charge over any of the assets in the property. So our pricing reflects that. So our interest is anywhere from 1.2 to 1.5% per month. It's calculated daily and it's rolled up. So that's important to factor in. If you're dealing with a contentious matter, some of those matters can go on for long periods of time. So we would then need to build that in to ensure that there is enough at the end for us to be repaid. So the origination fee, we have a 2% origination fee. In most instances, that is not 2%. So this we can bespoke that a little bit. We have a look at each matter and we decide, just in terms of the complexity as to what the origination fee is going to be. The 2% is the maximum that we'll charge. Generally, we're on about 0.5 to 1% at the moment. And on some of the larger loans, anything over 500,000, we waive the fee completely. So there's no monthly repayments or early repayment charges, meaning that if you ever come into funds halfway through a process, we can be repaid or reduced. If something sells or within that probate matter, you can send it over to us. We can reduce the loan so that the interest is less. And then we don't have a term. So it's open-ended. We can be repaid at any point. We stop charging interest at month 30. So from an FCA perspective, we're not allowed to charge interest past month 30. So we'll draw a line in the sand. Capital and interest that has accrued will then be payable as at month 30. And I think that is it. Yeah, so that's it. I mean, obviously, as I mentioned, we all know that they're very different. It's often worth a discussion to see where we can assist. As I said, I've probably spoken to a few people on this call over various matters, and some of them we were able to do, some of them we weren't for various reasons. If we can get to a point where we understand the matter, we prefer to say yes before we say no. So we'll always explore every avenue that we possibly can. We're the market leaders in this, so we're the only FCA regulated company that's currently doing this. We see ourselves as I said, market leaders. One of our founders is actually a solicitor, and obviously he saw a need for this, and he's very much involved with the business, and he keeps us afay with anything changing in the legal world itself. But yeah, that's my details over there. So if you don't have my details, there it is there. Yeah, if there's any questions, please do let us know. I'm going to stop sharing now. There we go. Now I can see my screen again. So yeah, I guess that brings us, if there's no other questions, or if anybody wants, put a question on or reach out to us directly, whatever it is, let us know. But I think that just about brings us to the end of this webinar. 9 minutes early. So we've done it. Oh, hang on. Questions just popped up. Okay, so Karen has asked, is funding available for out-of-court dispute resolution, i.e. mediation, early neutral evaluation, etc.? The answer to that is yes. So we can certainly look at that. As I said, just in terms of whatever the funding is, if funding is required to get it to a certain point, and then it's going to be resolved from there, we can look at that type of funding from there. It doesn't have to necessarily be go all the way to court. We will look at the full matter, so we will take a view and say, well, if there isn't a resolution, what will happen? But yeah, we will be heavily guided by you in terms of the matter, because you're involved with that. So I hope that answers your question, Karen. Okay, all right, perfect. So yeah, if there's no other questions, oh, there's one more. Okay. This master of the rolls is pushing out of the court resolution. Okay. All right. I think it's probably, it might be worth Karen having a chat about it, just to understand a little bit more about it. Just before I comment and say that it is certainly something that we can look at, i.e. non-court is the way forward. Yeah, there we go. Yeah, so, but certainly, I mean, if you want to reach out to me, feel free, and we can have a look at it and we can discuss it in a little bit more detail to find out, you know, how and where we can assist from a funding perspective. Okay. Right, so if there's no more, I think so. We're now 7 minutes ahead of time, so we can give you 7 minutes back. But yeah, I think it's just on behalf of the Surrey Law Society, myself and Andrew, it's just a thanks very much for your time. Thanks for joining today, and hopefully I'll be able to catch up with you in person at some point. Yeah, and we'll see you at some of the Surrey Law Society events.
Thank you.
Thanks very much. Thanks, Andrew.